Compromise is an act of negotiation in which both parties exchange something to obtain middle ground and arrived at mutual conclusions. Order 23 Rule 1 to 3 of Code of Civil Procedure, 1908 deals with compromise decree. Article 23 Rule 3 lays down the following condition to be satisfied before passing a compromise decree. Sus bandin. 1. Suit has been adjusted wholly or in part by any lawful agreement in writing and signed by the parties. The defendant satisfies the plaintiff in respect of the whole or any part of the subject matter of suit. 2. The court shall record such an agreement, compromise or satisfaction, and pass compromise decree accordingly when agreement relates to the whole suit. The court must, on being invited by the parties, record agreement and pass a decree in accordance with the agreement, and suit stop there. A court passing a compromise decree performs a judicial act, not ministerial act. Further proviso of Rule 3 provide that court is required to decide. The question arises where compromise, alleged by one party and denied by other party, that compromise has been made, and also provide for deciding question. No adjournment shall be granted unless reason to be recorded. Rule 3A of Order 23 provided that when a compromise is entered into between parties, it is not open for either party to maintain a suit for setting aside a compromise decree on ground that compromise was not for lawful, and explanation of Rule 3 provide that compromise or agreement which is void and voidable under the Indian Contract Act 1872 shall not be deemed to be lawful. However, the word not lawful in Rule 3A is a wider than similar word in explanation of Rule 3. Rule 3B of Order 23 provides that no compromise and agreement in a representative suit can be entered into without leave of court, and if any such agreement or compromise entered into without leave permission of the court, so recorded shall be void. Provision of compromise decree shall not apply to execution proceedings as mentioned on the Rule 4 of Order 23. In the case of Amiro Devi v. Julfiram, 2024 SC, the Supreme Court reiterated that compromise decree cannot be recognized unless it is reduced in writing and signed by parties. Appeal of compromise decree. Generally, according to Section 96(3) of Code, no appeal of compromise decree. But in the case Banwari Lal v. Chando Devi, 1993, SC compromise decree is appealable under Section 96(1) of Code on condition that when factum is in dispute. Factum dispute depends on case-to-case basis. To earlier 1976, compromise decree is appealable under Order 43 Rule M against Order 23 Rule 3. But by amending Act 1976, the aforesaid clause has been deleted. After 1976, right to appeal against order, recording a compromise or refusing to record compromise was being taken away. A new rule has been added in Order 43 Rule 1A. Section 96(3) shall not bar to such appeal, because this section is applicable to cases where factum of compromise or agreement is not in dispute. Party challenging compromise can file petition under proviso to Rule of Order 23 or can appeal under Section 96(1), in which he can now question the validity of compromise in view of Order 43 Rule.